Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, our beautiful country, but how we're going to fix this bad boy together. The content that I'm going to show you right now is an amicus brief from the DOJ. They just said to the entire world, AR-15 bans are unconstitutional. They laid out the entire amicus brief for the rest of the world to see, and I'm going to show all of it to you right now. The bottom line, guys, we are fighting. We are winning. We are gaining ground back. Is everything perfect hunky dory? Absolutely not. But we are doing things that have never been seen before. It's time to start going on the offense with things just like this. And if you're down for that fight, make sure you hit that like button, subscribe to the channel, and turn the notification bell on because this is the place that we're doing it. All right. Let's get right into this, guys. I am so amped to bring this to you. Make sure you are following me at Braden LOA on X so I can bring these things to you as they happen momentarily in most cases. But let's jump right into this because this is something that I'm really amped about. I'm looking forward to just showing you what the actual Assistant Attorney General said. So this is her, Harmeet Dillon, okay? Quote, the Second Amendment is not a second-class right. See you in court, Illinois. Proud of my civil rights team. Thank you, Jesus. Or, excuse me, that's Jesus. That's funny. And then we've got the actual document I'm going to show you here. All right. Although, thank you, Jesus can be appropriate. I'm just saying. Now let's go to the other one. Chad Mazzell. The AR-15 is the most popular civilian rifle in America and is used by tens of millions of law-abiding Americans for lawful reasons. This is coming from the Civil Rights Department in the DOJ. Total bans on AR-15s are a flagrant violation of the Second Amendment. Today, the Department of Justice filed an amicus brief telling the Seventh Circuit that Illinois' law banning AR-15s is unconstitutional under the Second Amendment. And I'm about to show you the actual document because it is fire. But I want to show you the actual AAG. This is actually Harmeet Dillon, and she made a message on this exact sentiment reflected in this amicus brief. Watch this.
Hello friends, I'm here in Washington, D.C. That's my balcony behind me, and the streets are being cleared here in D.C. for the 250th anniversary of the Army celebrations here, so that's a kind of a big deal here, a lot of roads being blocked off. Today in the Civil Rights Division, we filed a brief in the Seventh Circuit opposing Illinois' ban on so-called assault weapons. We have also worked today on advancing liberty on our college campuses, as well as election integrity issues and protecting your First Amendment rights of free exercise. So
I don't need to actually show you the rest of that. The important part was so-called AR assault rifles or assault weapons, okay? This is language coming directly from the DOJ. We now have 2 instances of amicus briefs that have been filed on behalf of gun owners from the DOJ underneath Pam Bondi. That's never been done before the first time, and now it's been repeated in under a month. Guys, the time to fight is now. Anyway, let's continue. I'm going to show you the actual brief because there is some amazing stuff that they lay out here. All right. So here's the document from the 11th Circuit, the Court of Appeals for the 7th Circuit. This is against Attorney General Kwame Raoul, okay? As you can see, Chad Mazzell, Acting Assistant Attorney General, and Harmeet Dillon, Assistant Attorney General. These are the people who you just saw right here, and the first tweet was from Chad. But let me get into this. There's a few pieces I want to show you here. This has never been seen before. Okay, let's get into it. President Donald J. Trump has instructed his administration to protect the Second Amendment rights of all Americans. Executive Order protecting Second Amendment rights. Attorney General Pamela Bondi has likewise instructed the Department of Justice to use its full might to protect the Second Amendment rights of law-abiding citizens. This case poses important questions about the scope of the Second Amendment's protections. The United States has strong interest in ensuring that these important questions are correctly resolved. That the Second Amendment is not treated as a second-class right, how many of you feel that way? And that law-abiding Americans in this circuit are not deprived of the full opportunity to enjoy the exercise of their Second Amendment rights. Listen to what they say in the introduction. Okay, guys, the way that this is worded leaves nothing on the field. All right, listen to this. 3 years ago, the Supreme Court issued a landmark decision meant to break a habit developed by some states of treating the Second Amendment as a second-class right, subject to an entirely different body of rules than the other constitutional rights. Fire. And they're talking about the Bruen decision, of course. Regrettably, not every state got the message. Just a few months after Bruen, Illinois outlawed some of the most commonly used rifles and magazines in America via so-called assault weapons ban. In doing so, Illinois violated the Supreme Court's clear directive that states cannot prohibit arms that are in common use by law-abiding citizens for lawful purposes. Common use was just invoked, Heller decision was just invoked, the Bruen decision was just invoked, and just in time for Kavanaugh to have more percolation for his assault weapons bans. Guys, the time to push is right now. Subscribe, like, share, follow me on X, @BradenLOA. This is the way. All right, let's keep going. There's 3 things that I want to highlight here. First, as explained below, key aspects of Bevis's analysis are wrong, even judged against the Supreme Court's Second Amendment case law that existed at the time. Second, multiple Supreme Court justices have since made it clear that they disagree with Bevis and other recent lower court opinions, and that the court is likely to grant certiorari in the next term or two to address the errors in those opinions. It's reaffirming exactly that. We're getting to the payoff. That's the blue coming up. Third, after this court's decision in Bevis, the district court held a multi-day bench trial, heard significant evidence regarding the issues in this case, and made factual findings that show that the act violates the Second Amendment as applied to semi-automatic firearms and attachments that are in common use by law-abiding citizens for lawful reasons. Again, Heller's common use. For all these reasons, the court should reverse course and affirm the district court's injunction. Guys, this is it. This is the one we wanted. Now, let me show you a few arguments. They put out 3 of them. The act violates the Second Amendment by banning AR-15s and other firearms that are in common use by law-abiding citizens for lawful reasons. Many of the banned firearms are arms under the Second Amendment. Remember that whole game where they play this whole judge shopping where it's like, well, the AR-15 isn't arms. It's not technically arms, right? They just said it from the DOJ. This is in a amicus brief going to the SCOTUS, okay? Let's keep on trucking. I got a few more things I want to show you here. B. AR-15s and other firearms banned by the act are in common use by law-abiding citizens for lawful reasons. Again, they are just hammering it all the way home. The common sense conclusion that the most popular civilian rifle in America is in common use by law-abiding citizens for lawful reasons is buttressed by the factual findings in this case. Guys, they are literally setting up a epic showdown. I mean, like, you could not ask for a better worded amicus brief. AR-15s are not especially or uniquely dangerous as compared to other firearms, semi-automatic handguns that are in common use. You see what they're doing? C. As a complete ban on AR-15s and other firearms that are in common use, the act violates the Second Amendment. Text, history, and precedent confirm that a legislature may not ban a class of weapons on the ground that the weapons are militaristic. Does it make sense how they're always talking about military weapons and military-style firearms and military-style assault weapons? All the buzzwords the gun controllers always use? They're getting in front of it right here. This is going to the SCOTUS. The Second Amendment's text does not exclude militaristic arms. This is coming from the DOJ. Keep going. The Second Amendment's history demonstrates that possessing at least certain militaristic weapons was a core part of the right to keep and bear arms. Guys, I'm only doing the talking, like the main points. Everything's linked if you want to check it out. But this is fire. Like, this is what we need to see. C. Second Amendment related precedent confirms that the government may not ban weapons on the ground that they are militaristic. Guys, this is exactly what you wanted to see if you are a pro-freedom 2A advocate. Number 3, the act violates the Second Amendment by banning the possession of magazines or other firearm attachments that are in common use by law-abiding citizens for lawful reasons. Again, they are hitting this and hitting this and hitting this and hitting this because it's that obvious. And we're coming up to the conclusion right here. For the foregoing reason, this court should affirm the district court's injunction. Chad Mazzell, Acting Attorney Associate General, and Harmy Dillon, Assistant Attorney General. Now we're going to have a little bit of a recap here. So guys, what we're talking about right now is the second amicus brief sent by the DOJ, once against the Ninth Circuit and once against the Seventh Circuit. We've never seen this before, ever. To be quite candid, this is a wet dream if you are opposing AR bans. Because now the DOJ has something that they've sent to the SCOTUS, which is going to supplement and buttress the point of what Kavanaugh said as more percolation. When you had three justices who wanted to take it up, the other three didn't, and then the one in the middle was kind of like, meh, we'll see what happens. Or excuse me, 3, 4, yeah, you get the idea. The whole point here, guys, you have a genuine action from a civil rights division in the DOJ that has done multiple instances of positive movement for the Second Amendment to the point where it could be categorized as historic. It really could be, because we've never seen anything like this. I don't know. You guys can tell me what you think. I personally think y'all should be amped and screaming from the mountains how incredible this is, but you know what? That's what the comments field is for. Let me know what you guys think in the comments right down there. I will see you on the next. Make sure you hit that like button, subscribe to the channel, turn the notification bell on, and I will see you on the next event. I'm Braden. Later.